The defense tried to get your case thrown out, but you won and you convinced the judge that this case should not be thrown out and should go all the way to trial. What is the likelihood that the defense is going to appeal the judge's decision as a last-ditch attempt to try and get your case thrown out? You want to know the answer? Come join me for a moment as I share with you some great information. Hi, I'm Gerry Oginski. I'm a New York medical malpractice and personal injury attorney. I'm shooting video today inside in my kitchen. It's freezing outside. It's about 25 degrees, and I had a few minutes to share this great information with you. Okay, so let's say you brought a lawsuit against your doctor claiming that he was careless and that his carelessness caused you harm and injury. Now, your doctor denies all of your allegations. Your doctor says, hey, why are you suing me? I did nothing wrong. And by the way, Mr. Patient, you caused your own harm and injury. And then he says, even if I did something wrong, whatever I did didn't cause you harm and injury. And then he says, you know what? If I did something wrong and I caused you harm and injury, guess what? Your injuries really are not as bad as you claim them to be. Those are the typical defenses we see in these medical malpractice cases. Okay, so what does that mean? It means your case has now gone through the litigation process. Medical records have been exchanged. Other documents have been exchanged. We've had an opportunity to question the doctor whom you have sued. The doctor's attorney has had an opportunity to question you in a process known as a pretrial deposition. Lawyers also call it an examination before trial. Now, at some point along this entire process, it might be 2 years down the road, your attorney tells the court, Judge, we have now finished all the discovery on this case, and we are technically now ready for trial. It's called filing a note of issue here in New York. And it's simply a document that alerts the court that we are now finished with all the discovery. The defense, in a last-ditch effort to try and get your case thrown out before they have to go to trial, makes a formal written request to the judge saying, Judge, we don't believe that Mr. Oginski and his client have a valid case. That's called a motion for summary judgment. They want the judge to go ahead and summarily review the papers and recognize that, hey, we don't have a valid case. You have to have the case thrown out and dismissed. The defense will do everything possible to try and get your case thrown out before you ever get to trial. So now, in order to go ahead and submit these papers to the court, it's as if we are having a trial, except it's just being done on papers. So now, what do they have to do? They have to put in evidence. They have to put in medical records when they attach it to their papers. They have to go ahead and get their medical expert to prepare an affidavit or an affirmation to swear that he's reviewed all the records and it's his opinion that there's no valid basis for a case, and go into explicit detail. Now, what happens after that? Well, then we have an opportunity to go ahead and oppose those papers. Except this is all being done on paper. There's no oral argument here. We now have to go ahead and literally go ahead and put in our evidence. We have to put in deposition transcripts. We have to put in medical records. We have to put in photographs. Now we have to obtain our experts to go ahead and review all the records. And then we have to prepare affirmations, or the doctors have to prepare affirmations to go ahead and explain why we have a valid basis for a case. And now the judge will have to decide who is more likely right than wrong. And importantly, the court will have to look to see if there are questions of fact that a jury has to evaluate. That's really what a motion for summary judgment is all about. The defense tries to explain to the judge that there are no questions of fact, that there are no factual disputes that require a jury to evaluate. Instead, they will always argue that there are questions of law that only the judge can answer. And in that instance, if the judge agrees with them, the judge will throw your case out and you will never get to trial. In this video, I explained what happens if the judge agrees with us instead and recognizes that you do have a valid basis for a case and that there are questions of fact, clear disputes that have to be resolved by a jury. When the judge gives us a decision in our favor on a motion for summary judgment where the defense tries to get your case thrown out, it doesn't mean we win your case. It simply means we have won this request by the defense to dismiss your case. That's what it means, and that there are questions of fact for the jury to answer, and that the judge, being the ruler of law, the person who decides the law, that there are no issues of law to be decided in this particular request. So what happens then? In all likelihood, the defense is going to turn around and not accept this trial judge's ruling. They're going to argue, look, we think the trial judge was wrong. We think the judge made legal rulings that are in error. And because of that, we are now going to appeal the trial judge's decision. If the judge rules in our favor, what is the likelihood that the defense will go ahead and appeal that decision? You know what the likelihood is? Extremely high. Why? Because my dog is barking. Must see something outside. I'll tell you why. It's because if they have another shot at the apple to try and get your case dismissed, they're going to do everything possible to go ahead and try that avenue of relief, to go ahead and try and ask the appellate court to see whether or not they agree with the lower court or whether they disagree. And if the appellate court disagrees with the trial judge, there is the possibility that the appellate court will throw your case out before ever getting to trial. So, why do I share this with you? I share this with you because people think that if they win their motion for summary judgment, it's automatic, smooth sailing all the way to trial. The answer is not necessarily. There's a good likelihood that the defense will go ahead and appeal, and that appeal could take quite a while before you ever get to trial. I recognize you're likely watching this video because you have questions or concerns about your own matter. Well, if your matter did happen here in New York, and you're thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a wonderful day.